Hello everyone, welcome to the third meeting of our 43rd season, and of course it's our opportunity to welcome Lady Brenda Hale. Last week he was a famous scientist and a member of the House of Lords, and this week we have the honour of welcoming someone who's also a House of Lords member, another crossbencher. I always think of the crossbenchers as bringing wisdom to the House of Lords. I'm a great fan of that. And of course, Lady Hale has reached the very pinnacle of the law profession in the UK. But before I say anything else, could I just give two welcomes? One is to Sir Brian Fender, who's here on the second row. He's on our advisory panel. He's the leader of various public institutions and charities, and he's a former Vice-Chancellor of Keele University. And I'm also pleased to welcome members, students at the Keele University School of Law. There may be some of them in here, and there will be some in the Strasse Theatre beyond. So I hope you enjoy the evening too. Returning to our guest. Now, I'm not going to go through all the details of her garlanded career. You've all seen her biography in our materials over the last 6 months, except to remind you that she became the president of a 21st century British institution, which might be discussed, the Supreme Court, and she's the first woman to be so appointed. Indeed, she has broken many glass ceilings in her career. Now, law and jurisprudence, a bit technical, isn't it? It's a bit arcane to some of us as citizens, but occasionally it hits the headlines. For instance, in 2019, I wonder if you remember the year, that was the prorogation dispute, and it's described as such in the House of Commons library, and it led to the Supreme Court, of which Lady Hale was then the president, to declare the actions of the British government, Boris Johnson government, to be unlawful or unconstitutional. They used both that words in the library documentation. And this led to even more fame for Lady Hale, because the New York Times, of course she was wearing that spider brooch, do you remember? She's not wearing it, it's a nice brooch tonight, but it's not the spider brooch. But that led the New York Times to have a headline, "The Brooch That Ate Brexit." It didn't actually stop Brexit, but it made a nice headline, and it made our guest even more famous. And since then, she's been on Desert Island Discs, MasterChef, not yet Strictly Come Dancing. I haven't... But there's still time, of course. And mention of the brooches leads me to mention Spider-Woman, which is Lady Hale's memoir that she recently published. And she'll be signing copies of that at the Waterstone desk at the interval. So I hope you'll take the opportunity to go and meet her. And of course, that book is about the law, and it's also about the challenges for women in a man's profession. So time is tight, so if you'd get your refreshment and your signed books as quickly as possible, we can come back here and we will have what I'm sure will be an interesting question and answer session in the World Affairs tradition. Baroness, Lady Hale's topic is central to one of the long-running themes or threads in Keele World Affairs. And the last occasion, as I recall, was Professor Meg Russell of UCL's Constitutional Unit, and she came here to talk about the House of Lords and whether it works or whether it should be reformed, etc., etc. But tonight's meeting looks even more widely at how we're governed, how well we're governed, and that's vital to us as citizens. Please welcome Lady Brenda Hale.
Well, thank you very much for inviting me. It's lovely to be here, lovely to see so many people here. And I am standing here rather than there because from here I can see all of you, and that means that all of you can see all of me, whereas little people like me are covered by screens if we sit at a desk like this. So I think there's probably more discrimination against little people in this world than there is against women. So there we go. To our muttons. The UK is said to be one of only 4 countries in the developed world not to have a written constitution. The others are New Zealand, Israel, and the Isle of Man. And Israel is actually something of a special case, because some decades ago, the Supreme Court of Israel decided that it did have power to strike down laws of the Knesset which were inconsistent with the basic laws which the Knesset had enacted as ordinary acts, but as the first building blocks towards a written constitution. And the power of a court to strike down provisions in Acts of Parliament which are inconsistent with the Constitution is the principal feature of a written constitution. It's also the principal reason why we're unlikely to get a written constitution in the UK. But more of that anon. Why don't we already have one? I think that the reason is that we have not had the sort of constitutional moment which leads a nation to adopt a written constitution. Our constitutional moment, our revolution, came in 1688. After nearly a century of battles between the king and parliament, during which there was a civil war and a king had been executed for high treason, parliament decided that the King James II had abdicated the throne, and they invited William and Mary to take his place, but on terms. William and Mary agreed to the conditions laid down in the Bill of Rights, which was put to them in 1688, and then enacted by Parliament with royal assent in 1689. This made it clear that sovereignty lay in the king in Parliament and not in the king alone. That has been the theoretical guiding principle of our Constitution ever since, that the king in Parliament can make or unmake any law, and no Parliament can bind its successors. There have, of course, been many constitutional developments since then, principally that government ministers should be members of Parliament, that they should be both accountable to Parliament but also chosen because they can generally command a majority in the lower house of Parliament, that the king should only use his prerogative powers on the advice of ministers responsible to Parliament, that the lower house of Parliament should ultimately be able to get its own way, even if the upper house does not agree, and finally, that the lower house of Parliament should be elected by universal adult suffrage. Some of this was done by Act of Parliament. The Parliament Acts 1911 and 1949 gave the House of Commons supremacy over the House of Lords, and the Representation of the People Acts established universal suffrage, but most of it was developed by convention, custom and practice which hardened into rules. These established a constitution on what is known as the Westminster model, where the government and Parliament are not separate from one another, although the third branch of government, the judiciary, is independent of them both. But there was never a moment where we felt it necessary to write it all down in legislative form. So what are such constitutional moments? Why do most other countries in the developed world have a written constitution? There are 3 main reasons. One is revolution. For example, the revolution of the American colonies in 1776, which led to the Constitution of the United States in 1787 and the Bill of Rights in 1791. And then, of course, there was the French Revolution in 1789 and many other revolutions throughout the 19th century. Another is war, specifically the need for a new start after a catastrophic war, as happened in Germany and Japan after the Second World War. And the third is decolonization. The British conferred constitutions on the nations of the British Empire as they achieved a degree of self-government. Examples are the British North America Act of 1867, which established representative institutions in Canada, and the Government of India Act in 1935. In the post-war decolonization in Africa and the Caribbean and elsewhere, the Act of the UK Parliament, which granted independence, would have a constitution annexed to it. That is why it is Britain which is referred to as the mother of parliaments, not the Westminster Parliament, as it is sometimes thought, although the constitutions which the British drafted were generally on the Westminster model. Now, there are some who argue that our constitutional moment has now come. What with Brexit and, how shall I put it, the relaxing of the traditional restraints on the power of the government, and in particular the Prime Minister, which we have seen in recent years. We've had a government which was prepared to test or transgress constitutional boundaries, for example, by giving notice to leave the European Union and thus automatically change the law of the United Kingdom without the approval of Parliament, or by trying to shut down Parliament in the run-up to this date when the UK would automatically leave the European Union, unless the deadline were extended. We've had a government which has sought to aggrandise its powers, as in its proposed changes to judicial review of administrative action, and to cut down the fundamental rights of individuals, originally by replacing the Human Rights Act and now by chipping away at the protection of human rights in specific areas, most notably in the recent Illegal Immigration Act. I'm never entirely sure whether the word illegal should be taken to govern immigration or act. Added to this have been the undermining of the ministerial code and attempts to undermine the parliamentary disciplinary procedures, and there have been attacks on the judiciary simply for doing its job, as detailed in last year's report from the all-party parliamentary group on democracy and the Constitution. Dominic Raab, remember him, for example, when a junior minister in the Ministry of Justice described the first Miller decision as an unholy alliance of die-hard Remain campaigners, a fund manager, and an unelected judiciary, which had thwarted the wishes of the British people, when it did no such thing. And he has floated the idea of legislating to give the government power to ignore judicial decisions which it doesn't like. More recently, there have been threats to leave the European Convention on Human Rights, particularly if the Supreme Court reaches a decision in the current Rwanda case which the government doesn't like. I hope and believe that our judiciary is robust and independent enough to stand up to these challenges, but the sum total suggests to some people that the traditional checks and balances, which meant that no one had too much power, have somehow been eroded. But although these things have provoked serious thought about the need for constitutional reform, I think it would take rather more than this to persuade our political class that now is the time for a written constitution. If the experience of other countries is anything to go by, they would first have to decide to set up a constitutional convention, and this would take evidence, consult widely, and produce recommendations. And what would those recommendations be? As a judge, I've had some experience of interpreting and applying the constitution of those Commonwealth jurisdictions, mainly in the Caribbean, where the Judicial Committee of the Privy Council is still the final court of appeal. And one thing that teaches you is that a written constitution doesn't answer all the really difficult questions. It will define the head of state, the legislature, the executive, and the judiciary, and accord to each their respective powers. It may deal with the appointment of public officials and the conduct of the nation's finances, but it won't answer some of the hard questions. For example, about the precise extent of the unwritten prerogative powers of the government, which we had to answer in the two Miller cases. And merely to say that a constitution will define the organs of government throws up all sorts of complicated questions, which would have to be answered by our constitutional convention. Most important is whether it should codify the status quo or should it try to modernize. Codifying the status quo would not be easy, but it would be easier than trying to modernize. This is always the case, as we law reformers know. Actually, the easiest, from law reform point of view, is to abolish it, but we can't exactly abolish the British Constitution. On the other hand, of course, whether or not it tried to modernize, it would be bound to provoke debate about whether it should modernize in particular areas. And we're going to go through them, see what you think, see whether you think there should be change in any of these. First, a written constitution would need to define the head of state. Now, support for the monarchy is currently quite strong, so I think we can probably assume that the head of state would remain the king or queen. The sexism in the rules of succession has been corrected, and the rule that the monarch cannot be married to a Roman Catholic has gone. But what about the monarch's own religion? How important is it these days to maintain the Protestant succession, which was the main motivation for the 1688 revolution? But if we don't maintain the Protestant succession, then the monarch can no longer automatically be supreme governor of the Church of England. And so one would have to consider all the matters of the establishment of the Church of England. This includes Parliament's role in church legislation, which is an effective veto, the monarch's role in appointing bishops, and of course the presence of 26 bishops in the House of Lords, about which no doubt Meg Russell had something to say when she was talking. Yeah. Now, it's tempting to see this as a bit of a sideshow. After all, Scotland, Wales and Northern Ireland get on perfectly well without the head of state as supreme governor of the church. And I'm not even sure that the Church of England would fight disestablishment, but I am sure that it would raise some really knotty problems. And next, what about the powers of the monarch? What, if any, residual power does the monarch have? To dissolve or refuse to dissolve Parliament, to prorogue or refuse to prorogue Parliament, to refuse royal assent to a bill passed by Parliament, or to choose or to sack a Prime Minister if, for example, there is a hung Parliament. Now, we dodged the issue in the prorogation case by assuming that the Queen could not have refused to act upon the Prime Minister's advice. But that is a view not universally held in those Commonwealth countries which are still monarchies. What about the House of Lords? Do we solemnly want to codify the present composition and its present powers? Ironically, the presence of the 92 hereditary peers and the 26 bishops would be relatively easy to codify, but both are debatable. What is the case for the continued presence of the 92 hereditary peers with their bizarre by-election rules for filling vacancies? What is the case for the 26 bishops when other religions have no entitlement to representation, although they may get their recognised leaders appointed, but no more? And above all, very much above all, what would the present patronage powers of the Prime Minister look like in statutory language? Would we not invite ridicule if we tried to enact them? Now, whatever the case for an appointed element in the Lords, and I'll come to that, surely it should be done by a more open, transparent, and meritocratic fashion than it is at present. And should peers serve for life or only for a fixed term? We all know that the present House is far too big, but can it be cut down? And of course, the big question is whether we should have a wholly or partially elected House of Lords, and if so, on what basis? Simply replicating the electoral system for the House of Commons wouldn't do. Everyone seems to agree that the second chamber should not become a challenge to the first. So various ideas have been floated. Most recently, the Brown Commission, A New Britain, Renewing Our Democracy and Rebuilding Our Economy. This proposed an assembly of the nations and regions, wholly elected, but on a different cycle and a different basis from the House of Commons, but without telling us what that cycle and basis should be. Really helpful. By contrast, the Royal Commission on the House of Lords, chaired by Lord Wakeham, concluded in 2000 that there was no case for a wholly or even largely elected House of Lords, but an independent appointment system should be supplemented by an arrangement which would give the regional electorate a voice in the selection of regional members. Their main point was that they wanted to retain the independence and expertise of the present House. But what powers should such a second chamber have? Now, at a recent conference in Oxford on the Brown Commission report, Professor Jeff King of University College London, a former legal advisor to the House of Lords Constitution Committee, pointed to all the advantages of the present House as a revising chamber. 1, There is no overall party control and a significant crossbench element. 2, members tend to be late in their careers. Yes, we do. Yeah. And have the benefit of the perspective that this brings. 3, members have time to focus and actually to read the papers, unlike MPs. 4, members are often highly competent, eminent people with a distinguished record, including former senior officials who can counter the government's arguments. 5, the House has more control over its own timetable than the Commons does. 6, even those members with a party affiliation are much more independent of the party whips because they're there for life. They have to be persuaded rather than threatened to toe the party line. And 7, the House has the power to amend and even delay legislation, subject to the Salisbury Convention that it will not ultimately thwart a promise made to the electorate in the ruling party's manifesto. I do love this idea that anybody reads political party manifestos, but there we go. So, with all those advantages, why not leave well enough alone? Strangely, the Brown Commission appeared to recommend that the Second Chamber should lose its present power to delay legislation while increasing the number of acts of Parliament which could not be repealed or significantly amended without the consent of the House of Lords. At present, under the Parliament Act 1911 and 1949, this only applies to an act to prolong the length of a Parliament longer than 5 years. I happen to think it would be a disaster to remove the present delaying powers, but there we go. So that's the House of Lords. There's the monarch and the House of Lords. That's enough questions, isn't it? But what about the House of Commons? Now, it would be easier to leave things as they are. The franchise and electoral law are generally already in statutory form, and the main features could simply be repeated in a written constitution. But that too raises some important points of principle. Presumably, we can all agree with the principle of universal adult suffrage, which is actually enshrined in many constitutions. But there are now serious proposals to lower the voting age to 16. And certain people are disqualified, including most serving prisoners and all members of the House of Lords, which is a sore point with some of us. Could go on about that. And what about our present first-past-the-post voting system? Its supporters see 2 main advantages. It usually yields a clear result with no need for the murky compromises of coalition. And MPs have a much closer connection with and responsibility towards their constituents, however they voted. But its opponents see it as fundamentally undemocratic, as we end up with a House of Commons which doesn't represent the balance of opinion within the country. Now, there are several ways of addressing this. The single transferable vote system, which was put to the people during the coalition government and rejected by them, is not properly proportional representation. A better system might be that in the Scottish Parliament, which retains first past the post in geographical constituencies, but then tops it up from party lists to reflect the popular vote as a whole. But there are lots of other different ways of doing it. But mention of Scotland, of course, brings me to devolution. Any written constitution would have to deal with devolution. Both legislative and executive powers have been devolved to Scotland, Wales, and Northern Ireland when the Northern Ireland politicians can get their act together. But we are not a true federation. First, there is no comparable devolution to England. And it's difficult to see how this could work for England as a whole. It is just too big. Now, my solution would be to divide England up into large regions which have some geographical, economic, and cultural coherence, perhaps modelled on the old Anglo-Saxon kingdoms. How about Northumbria, where I would come from, Mercia, where you would be, Wessex, Essex, and Sussex, which would be the whole of the south east, with London as a sort of District of Columbia on its own. No. It's not going to happen, of course, because the UK government and Parliament would have less control. But then we would really have devolution comparable to that in Scotland and Wales, with the potential for real levelling up. And second, there are those who argue that we're not a true federation, while the UK Parliament retains the power to legislate for Scotland, Wales and Northern Ireland, even in matters which have been devolved to them. Now, that is a tricky constitutional question to which different constitutions give different answers. You can imagine how difficult the demarcation disputes can be. So that's all the easy stuff, right? The most difficult question for a codified constitution will be how far to translate our constitutional conventions into law. Many of these have to do with the relationship between government and Parliament. Should it be expressly provided that the leader of the political party which can command a majority in the House of Commons shall be Prime Minister? It is so provided in the sorts of constitutions I've been talking about. Should it be left to each political party to decide how to choose its leader? Thus, as we have seen twice recently, giving the choice of Prime Minister to a small section of the population. Should the power of the Prime Minister to hire and fire ministers be regulated? And what about all the other controls, such as the ministerial code, over which the Prime Minister currently has such power? Should they be put on a statutory or even a constitutional footing? And what about the relationship between ministers and Parliament? Some of us were brought up with the idea that ministers were answerable to Parliament. Not only that they should not tell lies to Parliament, which appears to be a stumbling block for some, but also that they should resign if things go badly wrong in their departments, whether or not they were personally responsible. But I can think of only two clear post-World War II examples. Tom Dugdale, MP for my home constituency of Richmond in Yorkshire, resigned as Minister of Agriculture when his officials reneged on a promise to return land at Critchell Down, which had been requisitioned during the war, to its original owners. And Lord Carrington resigned as Foreign Secretary when poor intelligence reports meant that we were unprepared for the Argentine invasion of the Falkland Islands. Curiously, Carrington had been a junior minister in the Ministry of Agriculture at the time of the Critchell Down affair, and he had tendered his resignation too, but Winston Churchill had refused it. Said, "You better stay, Peter." And that is thought to be one of the reasons why he was so quick to resign over the Falklands affairs. But that is a very rare occurrence. So should it be enshrined in a constitution? And fundamental, of course, to this issue is the status of the civil service. Should it be put on a constitutional footing? Should the senior civil servants be appointed independently on merit, or should they be political appointees? Since the late 19th century, we have theoretically espoused the ideal of an independent, merit-based civil service which can serve a government of any political persuasion. But this has been undermined by bringing in advisors from outside, as well as perhaps by the increasing use of outside consultants to give the policy advice which the civil servants used to give. Now, written constitutions do tend to deal with public appointments and seek to achieve a degree of political impartiality, especially in critical posts such as the Director of Public Prosecutions. Back to the relationship between government and Parliament. Should we codify the principle that it's not only Parliament's job to pass laws, it's also Parliament's job to hold the government to account? That's the quid pro quo for the government commanding a majority in the House, and thus being able to get its own way most of the time. But do we really believe in it? And how much control should the government have over the agenda of each House of Parliament? It was regarded as a solecism when the House of Commons in 2019 voted to take control of the order paper, its own timetable, in the run-up to the Brexit deadline of the 31st of October 2019. Even in a Westminster model constitution, should the government have quite as much power over the agenda as well as the votes of the House of Commons? Of course, it's hard to believe that that incident, the House of Commons voting to take control of the order paper, was not what prompted the then Prime Minister to try and shut Parliament down by advising Her Majesty that Parliament should be prorogued for 5 out of the 8 weeks remaining before the 31st of October deadline. And I suppose that brings me to the relationship of both government and Parliament with the judiciary. At present, the independence of the judiciary is fairly well protected, both by the rules about security of tenure and by the current independent merit-based appointments processes. These could be translated into a written constitution without too much trouble, but like everything else, they would raise questions. Is security of tenure enough? Should there not also be rules about security of pay and pensions? Or rules about retirement ages? The age in England may just have been raised, but there are governments in Europe which have deliberately reduced the retirement age for judges currently in post in order to get rid of judges they don't like and achieve a more compliant judiciary. And not everyone is comfortable with the current lack of political input into the appointments processes, though most of us would view with horror the greater politicisation of judicial appointments. We are proud to be able to say, to the astonishment of the Americans, that we do not know the politics, if any, of most of our colleagues. I can make a jolly good guess about 2 of them. But the rest, no, not at all. Then, of course, there's the question of a Bill of Rights. The Americans soon amended their constitution to include a Bill of Rights. When the Canadians adopted their own constitution to replace the one which we had given them in 1867, they also adopted a Charter of Rights. All the modern Commonwealth constitutions, which I have seen, contain a list of fundamental rights, largely modelled on the European Convention on Human Rights, with some local variations. We are parties to the European Convention, and currently the Human Rights Act 1998 converts most of those rights into rights enforceable in UK law. So should our written constitution do the same thing? Surely a constitution without a Bill of Rights is unimaginable these days. And this leads on, of course, to the biggest question of all. The whole point of a written constitution is that it is a higher law. It controls the powers of all branches of government, including the legislature. There are certain things that the legislature cannot do, or can only do with a special procedure, such as a supermajority in one or both houses of Parliament, or a popular referendum, or both. This means that there has to be a body with power to decide whether the legislature has acted within its powers. That is a Supreme Court in most countries in the Anglo-American common law world, or a separate constitutional court in most countries with legal systems based on the European continental model. The Constitution of the United States of America does not expressly provide that the Supreme Court can strike down the legislation, not only of the state parliaments, which of course it can, but also of the United States Congress, if it's inconsistent with the Constitution. But the Supreme Court soon decided, actually in 1804, that it was the inevitable corollary of having a written constitution with a prescribed method of amending it. Most of the modern constitutions which I have seen spell out which parts are entrenched, that is, require special procedures to amend them, and which are not. And I'd like to give you a lovely example that we had. The Jamaican Constitution provides for a right of appeal to the Judicial Committee of the Privy Council here in London in certain circumstances. This right is not one of those entrenched in the Jamaican Constitution. So the Jamaican Parliament legislated to replace appeals to the Privy Council with appeals to the Caribbean Court of Justice. This has been set up by a treaty between 13 of the Caribbean states. But this was challenged in the Privy Council on the basis that the independence of the Jamaican judiciary is entrenched in the Jamaican constitution. So to subject the decisions of the Jamaican judiciary to an appeal to the Caribbean Court of Justice, which didn't enjoy the same entrenched independence, would be inconsistent with that. The fundamental rights of the Jamaican citizen would be in the hands of a court which did not enjoy the same independence from government as their courts currently did. That's a clever argument, isn't it? Shows you how good lawyers can be, including lawyers from Jamaica. And, somewhat to our surprise, we in the Privy Council agreed with them. So they haven't removed the right of appeal to the Privy Council yet, because they have difficulty getting a constitutional amendment to allow them to do it. So, if we were to have a written constitution, would any parts of it be entrenched? And if so, which? This would, of course, be inconsistent with what is generally said to be the fundamental principle of the British Constitution, that Parliament can make or unmake any law using ordinary parliamentary processes. Now, when a court has a final word in this way, it is natural for the politicians to want to pack the court with their supporters. The appointments process in the United States allows them to do this. And it means that a political party which doesn't currently enjoy electoral support can dictate to the political party which does have that support the answers to some pretty important questions, as we have recently seen in the United States with the overruling of Roe against Wade. Hillary Clinton does not think that that is justifiable in a democracy, and I would be surprised if many UK politicians thought that it was. So the greater the power of a Supreme Court, the more important it is that its appointment processes are not governed by party politics. But I have to say that the courts of this country are not looking for any more power than they currently have, so I doubt very much whether they would be supporters of a written constitution along those lines. So there are some very powerful reasons why we don't have a written constitution in this country and are unlikely to have one anytime soon. Turkeys and Christmas come to mind. But that doesn't mean that we should abandon any idea of constitutional reform. There are all sorts of things that could be done without a written constitution. The Institute for Government, for example, has just produced a report on its review of the Constitution. This is a very modest document, but its main point is that we should no longer make important constitutional changes almost by stealth, as has happened quite a lot over the last 2 decades. Examples are the introduction of voter identification, for example, or, possibly more sinister, the instruction to the Electoral Commission that it must have regard to the guidance that is given by the government, or the impeding of the independence of boundary commissions. Now, these are just 3 examples of things with important constitutional ramifications which have happened just by ordinary processes. So the Institute for Government is suggesting that we should have a process of identifying bills which are important to the Constitution and a special process for passing them through Parliament with much better scrutiny than they get at the moment. Now, this could be done. So that's just one example. There are many other things which I've touched on in what I've been saying, which could be done without a written constitution. We could disestablish the Church of England. We could reform the composition of the House of Lords. We could add to the list of Acts of Parliament which cannot be repealed or amended without the consent of both Houses of Parliament. We could strengthen the procedures holding the government accountable to the House of Commons. We could put the Ministerial Code and the Committee on Standards in Public Life on a statutory footing. We could put the civil service on a proper statutory footing, emphasising its political neutrality. Or, of course, as Francis Ward wants, we could go in the opposite direction. But we could do those things. We could even grant some real devolution to England. As a proud northerner, that is the reform which I would most like to see. Thank you.